and fathering him was charged with making threats to potentially SH Star OT, a school in Falmouth, Massachusetts, was arraigned and released on a $2,500 cash bail with conditions. He was not found to be a danger despite the Commonwealth asking for him. And I want to explain why, because I've had so many questions specifically about this. So what he was charged with is not an offense that qualifies under the 58 dangerousness statute. So in Massachusetts, we have a statute where the Commonwealth can move for the court to hold. This is what happened in the Kelsey Fitzsimmons case. She's held on a dangerousness, okay, because her charges do fall under the statute. You can move the court as the prosecutor to hold a defendant for 120 days without any bail. That means no amount of bail can get them out, nothing, they're in there. And the basis for that request is that they are such a danger to the community that there are no reasonable conditions that could ensure the community or a specific victim's release, okay? Now, if this was a charge that fell under the dangerousness statute, I think there is a high likelihood that he would have been held under the statute. However, because it falls outside of the statute, it doesn't fall within the statute, you have to have a regular bail hearing. And when you have a regular bail hearing, the presumption is release on personal recognizance. Because remember, one, everybody is presumed innocent until proven guilty. And the purpose of bail is to ensure the defendant's appearance in court. So what the judge has to evaluate, the bail conditions as they're allowed to evaluate in Section 58, which is basically the defendant, the nature of the offense and the circumstances, whether the individual defendant has a criminal record, whether there are any, weapons involved, is there an underlying restraining order, what are the ties of the, those kind of go into the facts and circumstances of the offense. What are the ties to the community? Do they have financial ability to pay? And you can't you can't set a $250,000 bail for somebody who does not have the financial ability to post it, because that's essentially holding them without bail. So you're entitled to the presumption of bail. So if the standard where we start is release on personal recognizance, somebody who doesn't have a record, there's no indication that he won't show up for court. So then what the court does is they set a reasonable bail that the defendant can possibly make, which is a $2,500 bail here with a number of conditions, which is GPS house arrest. This is an inclusion zone of his home, continue mental health treatment. Now, the facts underlying the case, I got a copy of the police report. I mean, they're very serious. I would take them very, very seriously if I was the Falmouth Police Department. If I was the parents down there, I would be super concerned. This is sort of the intersection between the law and mental health, because we can't simply rely on the courts to, control these people, particularly when they have not committed the next level of crime yet. So the court can only consider what they have in front of them, which is an individual who's alleged to have made threats, but otherwise has, no criminal record, has family community support, has a private attorney, so is likely to return to court. So the court's hands are a little bit tied in terms of what they can actually do, and so they use conditions of release to do their best to ensure the safety of the community. I mean, the only thing that you could do is, what you would do is you would lobby your state rep, your state senator, to change the dangerousness statute to, maybe we have to include, we rewrite it and we amend it to include threats against children, since this is, this is a common occurrence in this country. So I know it's really complicated, way to explain it, because we're looking at it, it's like, how could Catherine, how can you think he would be held as a danger if it was under the dangerousness statute? Because you can consider those things in a dangerousness hearing. In a regular bail hearing, you can't consider that stuff. So legally, I think probably maybe you could have gone up a little bit on the bail, but again, no record, has to be manageable. You can't set it at $500,000 if there's no ability to pay. It's essentially like holding the person without. So I do not blame anybody for the way that they feel, but I think this is where we need to be vocal. And it's not just the courts. It's not just the courts is the place of last resort. Please remember that. The courts, everybody blames the courts, but it's like the court is the last place. You know what I mean? This is the last stop. We need to be intervening from the front end.